They had the bipartisan system for so long. There's a group of people who were never included in that and who were never represented on the political stage at all, because even if they were conservatives or liberals, they were still part of the elite groups. So we can see that the courts fill a vacuum, and rather than transferring power to them in terms of like they becoming the overpowerful branch, they are still sovereign in the sense that they're now filling this vacuum in for the people. And there's something about transformative constitutionalism and providing this vacuum.
Authoritarian constitutionalism is also transformative. That the fact that Hungary is now doing Christian nationalist politics through its constitution is apparently transformative constitutionalism. Look, I have strong reasons to disagree with them, but I think it's worth then considering how you define it in the first place.
So how do you make sure that this transformed whatever society, whatever it is, isn't just a society where what judges say goes? What kind of state a transformed state looks like? If transformative constitutionalism is a vehicle towards that, how you then think of state authority being formed within that idealized structure, right?
But in abstract, the idea of transformative constitutionalism is material, substantial change. Cole Clarendon, as David writes about it, as a project of changing people's material conditions. And on those metrics, many people say it's an abject failure. And the question is then, well, where do we find the success? Do we find it in these formal changes? Do we have to find it in a society that's less unequal now? And
I think all these three countries do have a legal pluralist tradition, and that's something which perhaps adds like these challenges. So one thought I had is like a lot of your the problems you highlight with the stages almost seems to lend to like a fourth stage post your transformative stage.
Because all of the structures are there still in place, and it's those structures that need to be dismantled in order to see real transformative change. But of course, the difficulty with a structuralist account like that is that it can make it seem that change is just impossible. That if everything's governed by these structures, then how could we ever kind of radically transform anything?
It's a wonderful initiative.
The Globalsouth network opened new horizons for judicial cooperations.
Globalsouth network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Ayad, for the immense work that you're doing in the GSN, and the Globalsouth network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, full society, legal community, etc.
We are being criticized for doing our job and for upholding the federal constitution. Like I have said in the past, I will not bend to such lame pressures and insinuations.
Dr. Norman Riat, the founder and convener of the Global South Network, his visionary leadership has established a vibrant forum where judges, academics, and practitioners from around the world can share and exchange ideas.
I would like to point out that Dr. Riat's initiatives have not only enriched comparative judicial dialogue, have also fostered mutual understanding of the diverse challenges that courts face in safeguarding the rule of law and constitutionalism.
After all, what would you do as a colonizer from the global north, conditioned by a systemic othering mindset and driven by economic lust built on commodification, including the commodification of human beings?
This last question is not so easy, a bit complicated.
The Global South Network provides an important space to share experiences and learn good practices from one another.
Dialogue takes on particular importance thanks to Global South Network, which allow us to believe in a better world of the rule of law.
Thank you very much. It's my pleasure to welcome you to the 23rd seminar in Phase 5 of our International Interdisciplinary PhD in Progress Weekly Seminar Series, organised by the Global South Network. Before I begin, I would like to thank Dr. Norman Riat, lecturer in law at Leicester Law School and founder and chief convener of the Global South Network, for organising this weekly seminar series and for his continued efforts in bringing together scholars from around the world. My name is Dr. Tom Frost. I will be chairing today's session. I am a senior lecturer in law at Loughborough Law School, Loughborough University. I've held a number of academic positions in the UK in my career, and I generally specialise in public law and legal theory. So it's an absolute pleasure to be with you all today, and I look forward to what promises to be an engaging, thought-provoking discussion. Today, I am also joined by 2 discussants and 3 peer commentators. Dr. Alma Diamond is the first discussant for today's session. She's currently a visiting assistant professor at the University of Michigan Law School and will join the University of Texas School of Law as an assistant professor from July 2026. Her research sits in its section of private law, jurisprudence and constitutional theory, with a particular focus on the relationship between informal social norms and legal rules. Her work explores how social practices influence legal doctrine and how private ordering and public authority continuously shape one another over time. Dr. Alex Latham-Gambi is the second discussant for today's session. Alex's main area of expertise is constitutional theory. His current research is focused on the shared understandings that underlie legal and political practices and in the role that political institutions play in propagating those understandings through symbolic representation. He's published in the Oxford Journal of Legal Studies, the Review of Politics and Public Law, and is a contributor to the UK Constitutional Law blog. Brynne Guthrie is the first peer commentator for today's session. Brynne is a PhD student at the London School of Economics Law School. Her research examines the concept of legal continuity in the context of failed constitution-making processes and aims to shed light on the broader impact of such processes on understandings of constitutionalism. Before joining the LSE, Brynne was a research fellow at Max Planck Foundation for International Peace and the Rule of Law, and a law clerk at the Constitutional Court of South Africa and a Google Policy Fellow. Anjali Rawat is the second peer commentator. Anjali is a DPhil candidate at the Faculty of Law under the supervision of Dr. Rachel Taylor and Professor Sandra Fredman. Her DPhil research focuses on evaluating the legality of polygyny using the rights-based framework of equality and liberty in a comparative study of India and South Africa. Prior to joining the University of Oxford, Anjali worked as the law clerk and research assistant to Justice Rao at the Supreme Court of India for a year, and has also worked as a corporate counsel in Hyderabad for 3 years between 2015 and 2018. Kushiga Bakshi is the third peer commentator for today's session. Kushiga is a Murphy visiting assistant professor of law at the Tulane Law School. He's currently completing his Doctor of Juridical Science at the University of Michigan Law School. His research and scholarship focuses on constitutional law comparative law and international law. He is currently interested in theories of transformative constitutionalism and structural themes in constitutional law. His previous work has focused on Indian federalism, equal rights for gender, and sexual minorities and statelessness and detention. And last but not least is our today's guest speaker, Samara Majd Sharaf, who is a third-year PhD student in law at the University of Manchester. Her PhD assesses the legal continuities between colonial administrations and the constitutional orders established by post-colonial states. It then evaluates the ability of transformative constitutionalism to address this post-colonial legal inheritance. Today, Samara will present a paper drawn from her PhD research titled Addressing the Post-Colonial Legal Inheritance in Colombia, South Africa, and India. Does transformative constitutionalism present a solution? So, Samara, you will have approximately 30 to 35 minutes for your presentation. This is going to be followed by comments and questions from our discussants and peer commentators, who will each have around 5 minutes. Now, if time permits, we will then open the floor for a Q&A session with attendees who, if you have questions, please do post them in the chat as and when you have them. Samara, thank you for joining us today. The floor is yours. Thank you very much.
Thank you, and thank you for inviting me to speak. So, my presentation today proposes the theory that the transfer of legal authority during colonialism and decolonization. By way of overview, the paper can be split into two parts. The first looks at the similarities between the colonial period in stage 1 and the first wave of independent governments in stage 2. The key argument from this initial part is that colonialism establishes a post-colonial legal inheritance in which key legal features continue and are replicated from empire. The third stage, and this is in part 2, however, sees certain post-colonial states introducing transformative constitutional provisions. The paper will evaluate the extent of these provisions as to determine whether transformative constitutionalism can present a way past these retained features. Next slide, please. My research argues that in stage 1, the colonial administration establishes key legal features, institutions, and arguments that are used to legalize the use of excessive and extra-legal force. Then, in the second stage, these colonial modes of governance, namely the reliance on emergency rule and the perpetration of a two-tiered system, are replicated by the ruling class who inherit power upon independence. The continuation between the first and second stage gives way to what the research terms a post-colonial legal inheritance, as a similar legal framework to colonialism is reproduced by the independent state and has continuing negative consequences for those outside the elite class. However, in this third stage, we see a reshaping within the post-colonial state as transformative steps are taken to address both the legacy of colonialism and the long-lasting legacy of its replication. This change occurs under the framework of transformative constitutionalism, which challenges the traditional liberal interpretations of constitutionalism. Therefore, in part 2, my research assesses the implementation of transformative constitutionalism in 3 case studies, as to conclude whether that while it's able to address or make partial progress to some of the colonial inheritance, such as an excessive use of emergency powers and socioeconomic inequality, this alternative interpretation of liberal constitutionalism has less success in addressing religious conflicts and it's vulnerable to quick changing politics. Using the case studies of India, South Africa, and Colombia, the 3-stage process will firstly be demonstrated and outlined, and then the use of transformative constitutionalism to address the continuities from colonialism will be evaluated using the same case studies. So in terms of the post-colonial legal inheritance, these case studies were chosen as they exhibit high levels of constitutionality, and by that I mean they largely function as a democracy with electoral representation, regular elections, although those were sometimes restrictive, and no long-lasting military takeover. It is therefore highly probable that the key common legal features are also apparent in other less democratic post-colonial states. The research would thereby argue that the 3-stage model can be applied to a wide range of former colonies. However, it does not want to make the claim that all colonies undergo an identical process of decolonization. Further, the case studies were chosen due to their novelty and advancement of transformative constitutionalism and their relatively strong judiciaries. In part 1, and in stage 1, we look at the colonial administration. Colonial rule in the chosen case studies, and more generally, was a rule of violence. It established a two-tiered system where colonial members and those in favour with the colonial administration had access to political freedoms and representations, while the rest and the majority of the colony was largely governed by a rule of prerogative that authorised a heavy use of emergency powers to help the empire retain dominance or suppress opposition. Further, throughout colonialism, wide-scale inequalities were advanced as the empire relied on modes of divide and rule and indirect governance to establish its superior position. Using the chosen case studies, these modes of colonialism can be demonstrated. So to start with India, colonialism was sustained by the use of prerogative powers and force. The Governor-General was able to repress local opposition. In South Africa, a two-tiered system, to use the language of the time, justified interventions and a paternalistic style of governance. Then lastly, in Colombia, colonialism was sustained by exploitive labour relationships, which forced the indigenous population to provide labour as tributes to the Europeans as a form of repayment or for offering protection and conversion to Christianity. Then in stage 2, the post-colonial states exhibit similar tendencies to those demonstrated by the colonial administration. In particular, there are parallels between the legal systems of the independent state and that which governed the colony. This can be seen as the post-colonial legal inheritance. A main feature of which is the continued use of force perpetrated by emergency powers and high centralisation of power in the executive. The continuation in laws and legal structures also maintains the inequality of colonialism's two-tiered system, where there are high levels of fragmentation, land and religious conflicts, and large socio-economic disparity. This inheritance is best demonstrated through the significant emergency periods in each of the case studies. So again, starting with India, the 1975 emergency period saw the use of wide executive power to unconstitutionally amend the text of the Constitution. This included ouster clauses to bar judicial review and the restriction of fundamental rights such as habeas corpus, which was particularly harmful due to the state relying on extra-legal violence to detain those it viewed as opposition or a threat to national security. Apartheid in South Africa utilised both emergency provisions and formal laws that discriminated against Black South Africans under the existence of a dual state. An example of the latter is the Homeland Policy, which forced Black South Africans to live separately and only occupy 30% of the land. Further, as the Black population was pushed to rural areas, this removed their access to fundamental socio-economic rights, as the social amenities were concentrated in the cities. Lastly, post-colonial Colombia saw large bouts of civil war between the Liberals and the Conservatives. This saw an extensive period of emergency rule and a limited functioning of democracy, as the bipartisan system was sustained by patron-client relationships. It also then led them to take up arms during the Civil War. During this period, certain social groups, so those outside the elite, continued to be excluded from political participation and suffered from rural inequality. This included a lack of resources and poor land distribution, thereby leading famously to further conflict between guerrilla and paramilitary groups. Then moving on to part 2, in the third stage, which occurs later into independence, transformative steps are taken to address the legacy of colonialism. This change can either occur through the enaction of a new constitution or through the judiciary taking more progressive and active interpretations and novel advancements to their traditional role of checking state power and upholding fundamental rights. It is also often normally a combination of both, with the constitutional text relying on the interpretations by the judiciary. So with the case studies, South Africa and Colombia introduced new constitutions following apartheid and the civil wars respectively. And then in India, much of the progression came from the judiciary and their attempts to make amend for their actions following the emergency period. Notable features of transformative constitutionalism are an extensive Bill of Rights, constitutional supremacy that protects fundamental rights over state interests, land redistribution, and the judiciary increasing access to justice to redress previous inequality and marginalisation. Overview onto the key elements of transformative constitutionalism and how they are employed to address the legacy of colonialism, and then I'll focus more closely on its ability to combat the particular feature of the over-reliance on emergency powers. So the transformative framework has been utilised in the case studies to improve access to socio-economic rights, particularly for those who, under the previous regimes, were largely marginalised. Across all three case studies, the courts have increased access to justice by limiting barriers to standing, such as allowing for claims to be brought by civil society groups or reducing the threshold for what is deemed a valid writ. The case studies offer a rich body of examples of public interest litigation in which individuals are able to seek a judicial judgment if their fundamental right was threatened or violated. The courts can then issue direct orders and also often rely on civil society groups to monitor the situation following the case. This is demonstrated by the right to food case in India. Further, as to enforce socioeconomic rights, the courts have linked them to fundamental rights by stating that their satisfaction is an essential element to the right to life, as well in some cases, such as in Colombia, the courts have substantiated these rights by setting out the basic necessities that every individual should be able to access. Additionally, in an attempt to address past and during the emergency period in the 1970s through the 44th Amendment, the amendment introduced limits and requirements for a declaration of a state of emergency that raised the threshold for a valid declaration. It also restricted the potential for manipulation by preventing the executive from barring access to the judiciary for the enforcement of the right to life and personal liberty. The court has also increased checks on executive power by favouring a system of constitutional supremacy over political exceptionalism, as the court has developed the doctrine of the basic structure of the Constitution, which prevents the legislator from amending its key values, principles, and morality. This higher review standard works to ensure that the state function, even in times of an emergency, is in line with constitutional principles. Notably, South Africa has not had an emergency rule declared since apartheid. However, the provisions within the 1996 Constitution ensure certain safeguards when and if that time should come. Firstly, the Constitution moves away from a system of high executive power by requiring a 2/3 majority from the National Assembly as to approve a valid state of emergency. In doing so, the legislator reviews whether the declaration is necessary to restore peace and order. The courts are also given oversight over the process, as under Section 36, they have the discretion to determine whether any limitations to rights during this period can be justified in an open and democratic society. South Africa has also set up a tiered system which differentiates between states of national defence, disaster and emergency, with only the latter being seen as a true state of emergency that allows for the degradation of rights. And then following the large bouts of civil war in Colombia, the 1991 Constitution raises the threshold required for a state of internal commotion. Colombia is also transformative in its relationship with international law, as international humanitarian law is applied internally through a block of constitutionality and is used by the courts to govern the use of emergency powers. Then, unique to Colombia, the courts have repurposed emergency powers to the use of an unconstitutional state of affairs. This allows the judiciary to declare an emergency where rights are brought to a state of crisis if a significant amount of the population cannot access this right. So, linked to the previous discussion surrounding socioeconomic inequality, the use of an unconstitutional state of affairs has seen the court order collective and structural remedies to address and monitor wide-scale problems such as the right to health and internally displaced persons. Next slide, please. However, there are certain continuities that remain from the post-colonial legal inheritance that transformative constitutionalism has not been able to successfully address. This includes the religious conflicts that continue in the case studies, most notably in India, where the current government has enforced anti-Muslim policies. This limits the transformative project, as in order for transformative constitutionalism to be effective, there largely needs to be consensus, but the ongoing religious conflicts in India is demonstrative of a wider issue faced by transformative constitutionalism, and this is the rise of neo-imperial tendencies growing globally. This sees an increase in populist politics, which makes the risk of authoritarian governance more likely and sees the return of fragmentation and division in society. Further, this links to a wider issue in that change is largely dependent on the weak branch of the judiciary, who are still able to be manipulated and influenced by the executive. Therefore, even if reform is successful, it may be short-lived, as a manipulated or packed judiciary will offer little protection against the rise of authoritarian reinterpretation and manipulation of constitutional principles. A further issue in transformative constitutionalism links to the question of who decides this change and how well it is protected. While in the case studies of Colombia and South Africa, there was public participation and representation during the drafting of a new constitution, the day-to-day change and interpretation of the constitutional provisions are left in the hands of the elite, be that the political branches or the courts. This results in there being weak translation from the transformative text to practice. In South Africa, many academics have attributed this to the formal legal culture that remains in place. However, another explanation may be that the actors who change is dependent on do not want to give up their power or affect the status quo from which they currently benefit from. Work thereby needs to be done to the institutional structure in post-colonial states as to increase the entrenchment of these transformative provisions to better protect against abuse of executive power and human rights violations. Overall, it is apparent that the legacy of colonialism has long-lasting effects as the modes of colonial rule are reproduced in the independent state. Therefore, the success of the third and transformative stage is in its ability to address not only the legacy of colonialism, but the continuing legacy and reproduction of colonialism's legal features. The transformative stage is able to go beyond the traditional Western interpretation of liberal constitutionalism, as inherited from empire, to better suit and provide for local needs. In particular, the case studies show that the transformative framework is able to increase safeguards on executive power, improve access to rights, and work towards redistributing material resources and land. However, in order to truly remedy the continuing legacy of colonialism, the research suggests that more work needs to be done by way of institutional change as to better entrench the transformative framework. Thank you very much for listening.
No, thank you very much for that presentation. That was very thought-provoking. Raised a lot of issues I'm working on at the moment, and really, really well presented. So we now will turn to our discussants and peer commentators. Again, if any of you attending wish to ask questions, please do place them in the chat as we go, and then if we have time at the end, we'll come to them. So the first discussant here is Dr. Alma Diamond.
Thank you so much, Samara, for this fascinating and indeed thought-provoking presentation. I enjoyed thinking about your work. I'm going to spend the 5 minutes offering some, maybe the more generous thought is some reflections. This is not comments and reflections on maybe it's a conceptual point on how we define and think about the transformative project, you called it sometimes. So one question is going to be the extent to which we think about sort of the essence of the thing you're isolating as a formal legal provision, certain kinds of constitutional provisions. You often talked about transformative provisions, about what's formally happening in constitutions, versus the other thing you mentioned, it being kind of something of an institutional, social, cultural artifact, ways of interpreting and ways of litigating. So I'll reflect on some of that. And then in the end, if I have time, I want to offer just a thought or two on what the success condition is here. What is it for the transformative project to succeed? So what is it for a legal social system to be shorn of colonial, and do they look similar at all then? Towards the end, you mentioned something about local context, which I think is super interesting. So on the first point, so here's a confession. When I first read the abstract, I thought South Africa's post-colonial legacy and the transformative provisions, all of that was post-1994. I was kind of surprised, maybe at myself, thinking of apartheid South Africa as post-colonial. There's this tendency to think that was just colonial, right? Striking though is that that's kind of the same conversation people have about transformative constitutionalism. So one of the things people will say is like, if you are going to focus on the formal text, the South African Constitution is the most transformative. Yet it's the most unequal society. Socioeconomically, if you talk to people about what they think look at me referencing the people in abstract. But in abstract, the idea of transformative constitutionalism is material, substantial change. Colonial, Dennis David writes about it as a project of changing people's material conditions. And on those metrics, many people say it's an abject failure. And the question is then, well, where do we find the success? Do we find it in these formal changes? Do we have to find it in a society that's less unequal now? And if so, what have we done with the project? And so it's interesting that the thing you're noticing here between sort of even within discontinuities of legal form, continuities of social, substantial conditions, institutional conditions, That's the same debate that people are having about transformative constitutionalism. Some people would go, well, it just failed because substantially nothing changed. And some would go, well, success, because we see some different kinds of decisions or rhetoric, at least, in the courts. And so the lesson that you take, that you generally demonstrate, is also a lesson within transformative constitutionalism, the lesson being that legal form itself isn't the causally efficacious thing. There's something else. And the something else is the question. So what is the something else? Now, you've hinted at this, but I think the idea is that if we want to isolate what transformative constitutionalism as a project is, it can't be legal form. It can't be just social economic change. It's something about change pursued through legal means in a certain way. Now, you've hinted at this. You've hinted at interpretive styles. You've hinted at formalism in the legal culture. But I want to encourage you to consider the ways in which those features are really part of what transformative constitutionalism is, not sort of external constraints on its success, but part of really the thing, the phenomenon you're isolating. Because again, it can't be that you're isolating formal legal constitutional texts. You're isolating some way in which it lives in the world or doesn't. So I want to consider you drawing those things towards the end, where you talk about reasons this might have failed, into what you think you're really isolating when you're talking about it. I see I have 1 minute left. Now I have to rush. So I have a question for you about emergency powers, but I might actually just email you separately with that. So I wanted to ask something about your analysis of emergency powers. Let me end with just one more precise question, less of a rumination. And that is this observation that these societies remain vulnerable to religious conflict and quick changing politics. The question I had there is kind of relative to what? And this is my second question about what do we think, what is success like? So if the transformative constitutional project has succeeded, what kind of society are we looking to? So what baseline do we want? What is the comparator to say that these societies are still suffering from these divisions versus not? And so I think there's like a substantive vision of what success would look like that I'd love to have articulated a little bit more, because one of the thoughts is that even a constitutional system shorn of colonial legacies will have some problems. Like societies might have social and political problems even without those problems being post-colonial legacies. And I'd love to see them separated out in the analysis a bit more, or maybe just from this presentation. That was me over 5 minutes. I'm just going to stop very abruptly, and I'll email you with more thoughts. Thank you so much.
Thank you very much. So, Samara, what I'm proposing is I will go around the discussants and peer commentators, and then we'll give you this one if you wish to comment. Please do not feel compelled to respond to something you think about. The second discussant is Dr. Alex Latham-Gambi, so I'll turn over the floor to you.
Thanks, Tom, and thank you very much, Samara, for your great presentation. I'm going to try and be, I think I can be very brief, the main kind of question that I had actually follows on from Alma's quite nicely, I think. So Alma was talking about, what is the causal driving factor here, because it, as you kind of acknowledge it can't be the formal legal texts, it must be something other than that, and you point to a few things that are different other than the formal legal texts. And I suppose my question then was, what is the causal driving factor, and where does it come from, right? So if it's a different legal culture, or a different conception of legality, or a different conception of democracy, where does that actually come from? Because this is where I felt you did a very nice job at setting out a structuralist understanding of colonialism and the problems that countries face in the post-colonial scenario, where you can basically see a continuity of structure, right? So it becomes not quite, but almost meet the new boss, same as the old boss, because all of the structures are there still in place, and it's those structures that need to be dismantled in order to see real transformative change. But of course, the difficulty with a structuralist account like that is that it can make it seem that change is just impossible. That if everything's governed by these structures, then how could we ever kind of radically transform anything? So there must be something then that counters that structuralist determination of things, right? Or it's actually not a determination, is what you're saying, right? The structures are rigid, they are difficult to shift, they are persistent, but they're not impossible to shift, they're not impossible to change. And transformative constitutionalism, it can't just come out of nowhere, out of thin air, particularly because and precisely because you are very clearly and usefully identifying the same phenomena across different jurisdictions. You know, if it happened in one place, you could put it down to some, I don't know, kind of mini social movement, or large social movement, but localized social movement or something that kind of took over. But if it's happening over and over again, you think, no, there must be some kind of broader formation. It's not something that's culturally specific or historically specific to a particular jurisdiction. So I guess what is driving that? And then is this also a kind of a structure of a different type? So some people might say something like, well, you know, it's coming around at certain ideas of international law or something, or is it actually a more material type force or more idealistic type force? You know, what is it and what kind of thing is it? I hope that was clear, and I hope that was fewer than 5 minutes. Oh yeah, and just one little question which I just had that really kind of for you to clarify, because you mentioned that there's an ongoing problem with religious discrimination in India, and I'm just wondering, is that an isolated example? You seem to say it as if it applied across the board, but is there anything you can point to in the non-Indian cases to actually justify having that as a conclusion? So, you know, Sri Lanka is a multi-linguistic country. Colombia, there are indigenous peoples. You know, do you see parallels in some respects in those other cases? And if not, then perhaps that's not actually a general conclusion. But thank you very much.
Thank you very much, Alex. I will now turn to Brynne. Brynne, make your comments.
Hi, thank you very much. I'm also going to set a timer. I have a tendency to talk too much. I was thinking about, and kind of piggybacking off of what Alma said, what this sort of transformed constitutional system might look like. Because if we're going to think about legacies of colonialism and how colonial structures are perpetuated, whether that is, you know, the emergency powers or the two-tiered system, I think that there are other features that are obviously also legacies of that colonial history. You can think about kind of heavy legalization and bureaucratization, perhaps, of sort of the social structures and of everyday life. And I sometimes am perhaps concerned that when we start turning to something like transformative constitutionalism, which is its own form of legalization, right? Its own form of juridification. I wonder if we're also then not perpetuating perhaps not the same sort of structures of colonialism that you highlighted, of emergency powers, etc., but other features that have at least got some associations either with the colonial state or just kind of the post-independence states. We saw how this constitutionalism was perpetuated. So I think it's possible to critique transformative constitutionalism as saying that it is, yes, of course, active judiciaries doing something to hold the other arms of government accountable. But in doing that, what often happens is that there's perhaps a movement of concentration away from the executive and into the hands of the judiciary. And I think if we're trying to think about what type of society a transformed post-colonial state would look like, we would surely want one where there is a greater balance between the different arms of government and where things that are political can be discussed and debated within political forums, and where we don't have to turn to an elite body like the judiciary to necessarily enforce the redistribution or the rights protections that we would envisage in this ideal transformed state. And so I'm wondering if transformative constitutionalism, then, in perhaps the way you're thinking about it, is more of a vehicle than anything else. And if it is a vehicle, then what is that vehicle going towards, and how do you make sure that the vehicle doesn't become the end goal itself? So how do you make sure that this transformed society, whatever it is, isn't just a society where what judges say goes? And I think some of the examples that you perhaps gave are interesting to unpack, because so even, for example, the unconstitutional state of affairs in Colombia, right? Classically in legal theory, right, we would say that the sovereign, I hate to quote the evil genius Carl Schmitt, but, the sovereign is the person who controls the state of exception. And there you're saying, oh, well, here, the courts are repurposing the state of exception to point out that there is a problem with systemic violence or systemic violations of human rights. And that's exactly it, is essentially courts potentially taking over what we would otherwise have seen as the role of the sovereign in identifying, and the sovereign in a democracy we view as the people, right? So the courts very much usurping some of the powers and authorities, and in doing that, juridifying contests that we would usually think of as needing to take place at the political level or the super state level. I think that it's important to think about, if you're going to make these claims, what kind of state a transformed state looks like. If transformative constitutionalism is a vehicle towards that, how you then think of state authority being formed within that idealized structure, right? Because authority is going to be based on both what powers exist and how power plays out. And if all power is subsumed into the constitution and controlled by judges, I wonder how transformative it can really be at the end of the day, or if it's just a different type of centralization. So yeah, just some things that I've been thinking about, and hope it was helpful, and thank you very much. It sounds like a fascinating project.
Thank you so much, Brynne. I'll turn over to Anjali Rawat.
Hi, Samara. It was your presentation was lovely, and I gained a lot from it. I think for me also, I would like to continue the trend of comments and basically ask you questions about the limits of legal centralism and where does it bring us. And I think all these three countries do have a legal pluralist tradition, and that's something which perhaps adds these challenges. So one thought I had is a lot of your the problems you highlight with the stages almost seems to lend to a fourth stage post your transformative state. So has that been a thought you have encountered or grappled with? And especially, I think not the Indian example has gone way far into the backsliding, but I think South Africa with its increasing xenophobia and Colombia with its gender wars has also presented these counter examples of where the trend towards transformative constitutionalism has taken backdown. So I wonder if where do you envisage that as fitting into your project? And I think the other point I was wondering is, in terms of the examples you take, so is there when you sort of build this grand theory, other than the examples you have shown us, are there other arenas you step into? Because in some ways these are quite wide, right? So I know you gave us example of the right to food litigation, for instance, but I was wondering if these examples still remain within the bounds of court engagement, or do you step outside and perhaps think about other issues? I guess, for instance, in Colombia, the whole peace agreement perhaps stands out as one big moment, and I can't think of a similar example for South Africa instantly. But I would be curious if the engagement you're doing is just is starting to think about what I think scholars are now calling polyvocal constitutionalism. So do we step outside the current legislature, courts, executive domain and think of like how these other, institutions, fourth body institutions step in and play a role. But I think this project is extremely exciting, and anything which expands the comparative domain into the global south is of keen interest to me. So I look forward to reading your work as it comes out.
Thank you so much. And our final peer commentator, Kushaga Bakshi.
Hi, thank you again for having me, and thank you, Samara. This was fantastic. I really enjoyed the presentation, and I think you're on the right track. I don't have big theoretical or thematic insights because it seems like all these wonderful people before me have covered it already. The centralization and restraints on emergency powers, it worked for a brief period of time after the SR Bomai case, and while we had coalition governments formed with regional parties which were powerful, that sort of like there was some restraint on emergency powers, but how much of that you want to attribute towards sort of transformative, judicially driven constitutionalism versus just in federal states, if you have regional parties that are powerful and do coalition politics, you're sort of going to have less centralizing tendencies. That I'd be particularly careful about. I feel like I just should mention this. You might want to read INRE Article 370 and wonder if India is still a transformative constitution in the first place. So that's one concern. The other one, I think land redistribution is an interesting characterization. In as much as I think of transformative constitutionalism, I agree that it must entail some degree of material redistribution, and land is sort of the first place you want to go with that. Is South Africa the best example? Sure, they've prevented occupiers, but have they actually managed to do redistribution of land programs? I clerked for the South African court for some time, and I went to the land equity court, and Jesus, that was a bit of a mess. So I think Catherine O'Regan has a piece on the sort of continuing spatial discrimination that exists due to the lack of land redistribution. So that sort of might be one thing as a specific to consider. My two sort of broader comments are this, right? Like, I like the stage categorization. That said, it still leaves me wondering, okay, so then what, is transformative constitutionalism? And I would go with Alma's view that it entails some degree of like interpretive techniques and a judicial culture. That sort of seems like not necessarily judicial, but a constitutional culture. At least that was my reading of Clare as well, even though wherever it's gone now, it's gone now. So I might focus on, that's what I think the method to transformation is. I would think that if you're going to touch structural issues like the legacies of sort of, let's say that India retained the Government of India Act as a structure for doing the constitution, that's a whole separate interesting can of worms, and I'm curious to see what you do with that. I've been thinking about that because my own project is on federalism in India, and I don't have an answer yet. So I'd love to know what you think. That would just be fantastic. And the last thing I'd point out, this is not just a state of literature kind of thing, is that people are now starting to broaden the scope of transformative constitutionalism in two senses. One, the sort of like longer arc of the more progressive arc of this is that this is not just a global south phenomenon. You can think of this as a global north sort of phenomenon as well. I know that Michaela Heilbronner wrote about this a while ago, but you might also find examples. I think Bruce Ackerman makes a sort of compelling case for why the Reconstruction Amendments are functionally transformative constitutionalism. So that might be something to consider, that is this just a global south phenomenon? And in as much as it's not, is this really addressing a post-colonial inheritance, or is this more just another word for we want to do progressive constitutional politics, which is great, like we should want to do progressive constitutional politics, but that's an interesting distinction you might want to face. The other one, and I myself am skeptical of this, but I think it's worth pointing out, Mark Tushnet and a couple of German scholars have now started arguing that authoritarian constitutionalism is also transformative, that the fact that Hungary is now doing Christian nationalist politics through its constitution is apparently transformative constitutionalism. Look, I have strong reasons to disagree with them, but I think it's worth then considering how you define it in the first place. If you're going with Clare's sort of explicit CLS post-liberal definition, or are you going with a broader sort of consideration? So that might be just a few things to think about. That said, this was very exciting. I'm excited to see what you publish so I can read it. Thank you.
Thank you so much. Samara, I'd just like to turn back to you, and if you have any comments or responses to the discussants or peer commentators, I'd like to give you an opportunity to respond.
Thank you, everyone, for your comments. They were all very useful. I have things to say for everyone, but I think just in the interest of time. With how we define transformative constitutionalism, I think I could have done a better job to state this at the beginning, but I think the way my project sees it is as almost anti-colonial, and I think that, or moving past the colonial inheritance rather than the more general definitions of transformative constitutionalism. And I think that might provide a bit more context to some of the questions and comments, in that it's not solved all of the issues, but even with the religious conflicts and stuff, the secularism is a colonial inheritance, the way I see it in India. The divisions between the Hindus and the Muslims, but then also with the Sikhs and Christianity, that's left over from partition, but also from how secularism took form during the colonial period. So I think it's because in seeing it more as moving past the colonial inheritance of what was left and the adaptation of it to fit the local needs, I see that as the vehicle of change, and that as moving forward to some sort of social change. It's still within the liberal constitutional framework, so there are things that aren't going to be, there's things that are just inherent problems with liberal constitutionalism that remain problems in my research and with transformative constitutionalism in the case studies. But I think comparatively, even with land conflicts, the fact that there are land provisions is something that we should look at, because in Kenya, for example, in Kenya or other African colonies, the white settlers and the white communities got to keep hold of the entire of their land. Their post-colonial constitutions and their charter of rights included these provisions that allowed them to keep the land in the first place. So the fact that there even is land redistribution in South Africa is more progressive than some other colonies of post-colonial states. I think I wrote down a lot, sorry. I think that with the state on constitutional affairs, or with how we see the judiciary and putting power into the hands of the judiciary, I think the Colombian constitution and the Colombian context is interesting, because they had the bipartisan system for so long. There's a group of people who were never included in that and who were never represented on the political stage at all, because even if they were conservatives or liberals, they were still part of the elite groups. So we can see that the courts fill a vacuum, and rather than transferring power to them in terms of like they becoming the overpowerful branch, they are still sovereign in the sense that they're now filling this vacuum in for the people. And there's something about transformative constitutionalism and providing this vacuum that my research looks more into, in the sense that it allows the people who, or the groups and societies who, under the traditional liberal framework, are not able to get access to rights, or who suffer from socioeconomic disparities and inequality. Transformative constitutionalism presents a way for them to be able to access these rights, or access justice, or just have their opinion and stuff heard in the courts in a way that the traditional liberal framework doesn't allow it. So I think that's also a way of looking at my research, in that it separates the traditional liberal framework and traditional liberal interpretations that we see more in Western countries, and how they were applied in the colonies compared to how in the transformative stage that they then get moved past. But I agree that transformative constitutionalism, and there's a lot of backsliding. I hint at that at the last stage of my chapter, the last stage of my thesis, but I don't look at that completely. But then there is something to look at, in that there's a fourth stage, or that this liberal framework is circular, and that there are tendencies to go back to stage 2 with colonial tendencies and features being reproduced. I don't think I've answered everyone's question or commented on everyone, but that's just initially.
Absolutely fine, do not worry. Hopefully these are ideas that you can we can go away with and think about and speak to the other discussants and commentators as well. We have a couple of questions in the chat, which again you may want to take note of, or if you wish to respond to them. We have one from Getitude. I wonder, this is quoting, I wonder about the place given to the content of the constitutions themselves in the notion of transformative constitutionalism vis-a-vis the colonial legal institutional arrangements. Second point they make, what role should the political branches play in the idea of transformative constitutionalism compared to the judiciary? Jude has noted, in response to a point that was made earlier, transformative constitutionalism may be a contextual, universal phenomenon. Again, Samara, if you have any comments or wish to respond to these, you're most welcome.
I think there was an article recently, and I forget its name, about looking at reforming the transformative separation of powers, and I think that is something that gives transformative constitutionalism a new light almost, in the sense that a lot of the work now, and even in my presentation we talk about the judiciary, but maybe for transformative constitutionalism to be more long-lasting, more attention is needed on the legislator, rather than it being judiciary and judge-led. We maybe rethink, and then this affects the separation of powers between the executive and the legislator in a traditional liberal constitutional framework, and think about how we strengthen the legislator, and included in that we give more power to fourth branch institutions. I think the case studies of India and Colombia have demonstrated quite well that the use of civil society groups and ombudsmen to monitor the state action, and that sort of external function of monitoring can progress and actually advance these structural orders and direct orders that the courts hand out. And then they make them more long-lasting in that sense, because they can keep the case going on for a long time, and then also adapt with the changing circumstances and introduce new direct orders. So maybe we think about the legislator and then also giving more weight to these fourth branches in order to make transformative constitutionalism a more long-lasting framework.
Thank you. So we have a couple of minutes left, so I'm just wondering if anyone is attending who wishes to ask a question. I just want to give you an opportunity to open it. Oh, Anjali has a hand up, so I'll pass over. Anjali, please.
Only if I can, if there are no other questions.
Please go ahead.
I think, Samara, this was more of a curiosity point, but considering the colonizations in all these three countries have like slightly different contexts. And I think I also asked this question because I'm struggling with this when I compare India and South Africa and the family laws in these two countries, that you have like very different inheritance, so to say, when you compare these contexts. So I wonder if like that difference between like Colombia, India, and South Africa has posed some challenges for you in the process.
I think it is difficult to compare because they do take place, and the way that change happens is slightly different in each of the case studies. But I think what's helped me is identifying like common features of how this colonial inheritance takes place in each of the case studies and focusing on that. I think this is also an answer to someone's comment or question, but the inheritance, the way I look at it in my thesis, occurs through emergency powers and the reliance and over-centralization in the executive. And then we have land and religious conflicts, and then socioeconomic disparities. So those three lenses has helped me narrow down my focus, because that's what I've identified as the key features of this post-colonial legal inheritance. I don't know if that answers your question, but I think that has helped how I look at it through that framework and seeing, and that also links with the comment on what motivates this change. The case studies that I have the transformative constitutionalism aspects and stages came about in line with global consensus about constitutional making. So on international law and globally, there was much more constitutional making to include Bill of Rights and have the judiciary oversee this during the 1990s, and that's where that's where all three of my case studies progress in terms of transformative constitutional making. So there's definitely something to say about the consensus with it being an international law and transformative constitutionalism relationship with international law and what gave way to the change in the case studies. I don't know if that answers your question.
I may, just in case no one else is asking, I may indulge the joys of being a chair and just have a very quick question, Samara, because you're talking about inheritances. So I was just wondering, have you engaged or is any of your focus on colonial era record destruction? Because I know you mentioned Kenya as well, but obviously that happened in India, across the British Empire and other European empires as well.
Sorry, colonial records?
So colonial era record destruction. So before formal decolonization, that the European countries literally destroying the past. So actually shaping the inheritance that these countries are going to have.
I looked at it briefly at the start of the project, but I've not included it in the thesis. But I think it's this form of censorship, and I think that is a big part of the colonial inheritance, and this idea of criminalizing dissent and using force and violence to repress the opposition, that all the colonial encounter really gave way for this idea of excessive and manipulated uses of executive power. And I think that the destruction of records is an example of that. But I think that's on a similar, I would say they're comparable.
Thank you very much. And I'm aware we are a few minutes past 4 p.m. So unless anyone has any other questions, I will bring this to a close. I'm not trying to turn this into a Viber. Please don't worry. So huge thanks to Samara for the presentation. It's really, really fascinating piece of work. She's going to make a really valuable contribution to post-colonial literature on inheritances and transformative constitutionalism. I'm really, really interested to see how your future work goes as well. My thanks to the discussants, Alma and Alex, and the peer commentators, Brynne and Charlie Kushiga, for their comments and contributions to today's discussion, and indeed everyone who attended and participated and asked questions as well. The Global South Network warmly welcomes PhD students from any discipline and any part of the world to present their research and receive interdisciplinary feedback. Anyone interested in presenting their work or participating in a future session is encouraged to contact Dr. Nauman Rayat, founder and chief convener of the Global South Network, using the email address which is going to be provided in the chat. leicgsn@gmail.com. We hope you will join us again for the next seminar, the 24th seminar in our series, same time next week. Thank you once again for joining us today. Take care, look after yourselves, please stay cool, and have a wonderful day. So goodbye.
Thank you very much.
Thank you.
Thank you.